Your name and image are as important as your talent. One of the things that distinguishes action sport from traditional sport is the ability of action sport athletes to express their unique personalities. Action sport typically involve heightened interaction with fans and crowds, and action sport athletes are allowed and even encouraged to develop and publicize their public personas. Action sport athletes are also skilled at using technology to convey all of their colorful attributes and accomplishments, authoring blogs, building fan page on social networking sites, and using Twitter and other new media to promote themselves. Because distinctive personalities play such an important role in this industry, it seemed appropriate for this inaugural article for Group Wise website on legal issues to focus on why it's important for athletes to vigilantly protect their name and image. The legal doctrine that protects a famous person's name and image is called the right of publicity. The laws concerning the right of publicity can vary from state to state. In general, the right of publicity prevents someone from using a famous person's name or image for a commercial purpose without consent, whether it's in a comic book, video game, or domain name. In some states, the right of publicity also protects a famous person's voice, persona, and personal information, and in a few states this right extends to a famous person's name and image even after death. Because athletes can be very marketable, they are often the subject of unauthorized exploitation of their name, image, or likeness and involved in the litigation that result. One of the most well-known right of publicity cases involved former professional hockey player Tony Twist, who had a reputation as an enforcer and was known for his violent tactic on the ice. The defendant was Todd McFarlane, a creator of the popular comic book series Spawn. McFarlane, who was a hockey fan, named several of the characters in his stories after professional hockey players. One of the characters in the Spawn storyline was named Anthony Tony Twist Twistly, a nefarious, hideous-looking comic book villain. The real Tony Twist sued McFarlane to violation of his right of publicity under Missouri law. Although McFarlane argued that his Tony Twist character was protected by the First Amendment, the court disagreed, and a jury awarded Twist $15 million in damage. Twist reportedly settled for a $5 million payment from McFarlane's insurance company. Two lawsuits were filed recently involving NCAA football and basketball players and the virtual players in video games who closely resemble them. Sam Keller, former quarterback for Arizona State, filed a class action against Electronic Arts and the NCAA for violating his right of publicity by using his attribute, jersey number, height, weight, skin tone, hair color, home state, and playing style in the NCAA football video game without his permission. The lawsuit also alleged that the NCAA breached its contract with college players by licensing their likenesses to Electronic Arts without the players' permission. The case is just starting, but the potential damage are substantial. This lawsuit followed a recent settlement for $26 million involving retired NFL players who sued the players' union for following Electronic Arts to use their identities in the Madden NFL game without permission or payment. Just a few weeks ago, Chris Bosh, a member of NBA Toronto Raptors, scored a victory when a court awarded him ownership of 800 domain names including chrisbosh.com, which had been registered by a cyber quarter. A complex right of publicity case involving fantasy baseball and Major League Baseball advanced media, the internet arm of Major League Baseball, highlight how the use of someone's name or likeness is weighed against the First Amendment free speech protection. For several years, CDM Fantasy Sport had licensed from the Major League Baseball Players Association the right to use baseball players' name in its fantasy sport league. A few years later, however, the Players Association entered into a license agreement with MLPAM for the right to use players' name and playing records. MLPAM then demanded that CDM Fantasy Sport and other fantasy sport companies pay to become licensees of MLP's fantasy game. Thank you.